Hi, everyone. Thank you for joining us for the webinar today. I just want to start with a quick disclaimer. This presentation is for educational purposes only. It is not considered legal advice, and it does not create an attorney-client relationship between myHRcounsel and yourself or your company. We'll have information at the end on how to contact us if you have specific questions. And so you can get on with your day. We'll move through this information rather quickly. So what is political speech? Political speech can be verbal comments or discussions. It could be a comment, photo, like, upvote, or share on social media, clothing, pictures, posters, bumper stickers, any verbal or visual material referring to political parties, candidates, elected officials, views on divisive or political issues, any other topics involving the legislative, judicial, or executive processes. So it really encompasses a lot of things, but it's kind of, to quote a previous Supreme Court decision, you'll know it when you see it. So the laws of political speech can be prohibited by the employer, or the employer may be prohibited from making rules about the political speech or taking adverse employment action due to the political speech. So it kind of goes both ways. Both the employer and the employee have some restrictions on what they can and can't say, and this is part of an interacting web of state and federal laws. So the National Labor Relations Act is the first law we're going to talk about with regard to political speech. When we talk about the NLRA with regard to political speech, we are mainly talking about Section 7 of the NLRA, which prohibits employers from making rules against or taking adverse action because of any speech or actions regarding unionization, raising awareness of unsafe or unfair labor conditions, and joining together in a concerted effort for mutual aid. So this type of speech is protected. You cannot take an adverse action against an employee for engaging in it or prohibit it altogether. If an employee posts the manager is a Republican and that is why he's opposing the union, that's political speech, but that's also protected speech. If an employee talks to other employees about what to do about unfair working conditions, safety, wages, compensation, benefits, terms and conditions of employment, that is protected speech. So if employees are talking to each other either in the workplace or on social media about those things, you cannot prohibit that. You cannot prohibit talks about unionization or unions altogether, either at work or on social media. Even though unionization is a very polarizing and political issue about which many politicians have expressed opinions, even if you have restrictions on political speech at work or on social media, that topic is off limits. If an employee posts, if Democrats controlled the House, we would get paid sick leave and higher compensation, and another employee likes or upvotes the post, they are engaging in protected activity because they're organizing for they're making a concerted effort for mutual aid, and you cannot prohibit these discussions or take adverse employment action. Now, the NLRA prohibits and promotes certain activities for management as well. So when it comes to unionization, activities that management can engage in is giving facts, opinions, and examples. So we use the acronym FO. So you can give facts about what happened to other companies, when they unionized. You can give your personal opinion about unions, and you can give examples about other companies that are covered by a CBA, and just examples of their working conditions. But this is facts, opinions, and examples. Activities that management is prohibited engaging with respect to unionization and political speech are threats, interrogation, promises, and surveillance. So we use the acronym TIPS. So management may be violating Section 7 if they tell an employee that they will be fired or that the company will be shut down if the employer votes for the union. So that is political speech that is banned for management or HR. Asking employees questions such as, why do you want a union? What is the union promising? Who went to the union meeting? All of those questions violate Section 7. So that's, again, political speech that is prohibited for management, as does promising employees better terms and conditions for opposing the union. All of this kind of speech on behalf of management can face consequences for engaging in any of this type of speech under federal law. So laws of political speech, again, state and federal laws prohibiting discrimination and harassment, Title VII of the Civil Rights Act and many state human rights laws prohibit discrimination in the workplace on the basis of race, religion, sex, national origin, sexual orientation, age, disability, other protected characteristics. So employers have the ability and the obligation to prohibit discriminatory and harassing actions, words, visual material, other conditions in the workplace that would violate Title VII and state human rights laws. Now, even if they're expressing a political opinion, so right now the rights of transgender persons is currently a political issue. Many people have strong politically based opinions about transgender people and their rights. But you can and should prohibit an employee from saying things in the workplace, posting things online, or displaying any type of material in the workplace that would harass or discriminate against a transgender person. You must follow Title VII and protect your transgender employees. You should follow this consistently. No employees should be permitted to create a hostile work environment through their behavior, through their words, through their display of offensive material, either in the workplace or online. White males have sued for discrimination and harassment. If a woman employee posts "kill all the white men," that should also be prohibited, even though white men are not considered a protected class necessarily, because we think of them as sort of being the standard. But a post like that would discriminate upon race and sex. And so you should make that woman employee who posts that take that down, just as you would make someone take down an offensive post about transgender people. You should make your policy on discrimination and harassment very clear and prohibit any speech, political or not, that harasses or discriminates against the employee. One thing about the transgender issue, if you have an employee who claims it's against their religion to use a transgender person's correct pronouns, because they believe God created two genders and they can't be changed, the solution is to require that employee to use that person's name instead of a pronoun if they must address or refer to that person. But misgendering is not allowed. You cannot allow an employee to use the incorrect pronouns. So that's just kind of a tip on that. So laws regulating illegal off-duty contact. So California, Colorado, Louisiana, Minnesota, Missouri, Nebraska, Nevada, South Carolina, and West Virginia all criminalize interference with an employee's political activity. So if you're creating rules limiting political activity, and this is political activity, or if you are disciplining people for going to a rally or something like that, that is criminalized in those states. Washington, D.C., Illinois, Iowa, Louisiana, New York, Puerto Rico, and Washington State prohibit discrimination against employees either based on party membership or their electoral activities. So you can't treat Democrats or Republicans better than, progressives or uh, social democrats. Any sort of party can't be treated more favorably than another. These states violate discrimination based on party membership and also their electoral activities. So no interfering with voting or discriminating against employees based on how they claim they voted. Arizona, Georgia, Iowa, Louisiana, Massachusetts, Minnesota, Missouri, Ohio, Oregon, and Washington State protect employees for signing petitions and making campaign contributions. So you can't regulate that within the workplace. Connecticut has a law that subjects private employers to liability, including punitive damages and attorney's fees if they discipline or terminate their employees for exercising their First Amendment rights, unless the employee's activity substantially interferes with the employee's job performance or the working relationship. North Dakota law makes it a discriminatory practice to fail to hire or discharge an employee because he participates in a lawful activity, which includes making political speech, off the employer's premises or during non-working hours, as long as the activity is not in direct conflict with the essential business relators of the employer. So all these laws protect legal off-duty conduct. If you've got an employee who is participating in the January 6, 2021 Capitol riot, even though that is political activity, because they were off duty and their conduct was illegal, there's no protection for that. So the protections only go to legal off-duty conduct. Voting laws, almost all states have a law prohibiting an employer from interfering with an employee's vote. Generally, this includes disciplining or taking adverse action unless an employee promises to vote a certain way or providing incentives to vote a certain way. This would violate a state's voting leave law or making it easier for one party to take time off to vote than members of another party is still a violation, even if you're in a state that does not have voting leave laws like Connecticut, Florida, Ohio, Idaho. Even if you're not directly interfering with an employee's vote, I would advise management and HR to refrain from any talk or visual material regarding elections and political candidates. The CEO or HR office should probably not have a Biden 2024 poster in their office because it may intimidate employees into believing their employment is contingent on the way that they vote. So even though it's political activity and affiliation is protected in some states, I would say it's good practice for management and HR to remain neutral in the workplace. Laws of political speech that do not apply is the First Amendment. Do not let an employee tell you you are violating their First Amendment rights if you are a private sector employer. Now, it's different for public sector employees, but if you are a private sector employee, the First Amendment does not apply. The First Amendment prohibits the government from making laws abridging speech. It does not prohibit you. As mentioned before, Connecticut does extend First Amendment protections to employees in the public However, if the employee's activity substantially interferes with the job performance or the working relationship, this protection does not apply. So does the First Amendment protect your right to go out on the street and say racial slurs if you're not bothering anyone or just walking around your neighborhood saying racial slurs? Yes, the First Amendment cannot make a law prohibiting that, but with the Connecticut law, if this protection does not apply, if it interferes with the job performance and the working relationship, obviously using racial slurs at work on social media interferes with the working relationship. Navigating the law, know the laws of your state, first of all. Second of all, make sure your social media policy complies with the NLRA. There have been recent changes that have made most social policies non-compliant. In some states, you're prohibited from telling an employee to take down all Trump 2024 posts. Even where the states where you're not prohibited from doing that, you shouldn't overreach into the lives of employees, but when something gets posted on social media that would violate discrimination, harassment policies in the workplace, you should prohibit that, and your social media should make very clear that employees are not allowed to post material that would violate those policies. Your policies should also direct the employer to put a disclaimer when they refer to your company or identify themselves as employees of your company on social media, such as the opinions are mine and not the opinions of my employer. So you cannot, as far as navigating the law, you cannot prohibit an employee from saying the manager is a Democrat and that's why we need to fight for fair wages. You cannot prohibit an employee from saying the manager is a jerk and a Democrat and that's why we need to fight for fair wages. You can prohibit an employee from saying the manager is a racial slur and that's why we need to fight for fair wages. Again, North Dakota prohibits employers from regulating legal off-duty conduct, but even North Dakota's law states that the activity must not be in direct conflict with the business-related interests of the employer. It is legal for an employee to post anti-Semitic statements on his social media, but it conflicts directly with your business-related interests, which are not getting sued for religious harassment and discrimination. As I said before, and I'll wrap up here because we've gone a little over, laws are changing and laws may apply to your state but not another. If you pull a social media policy off the internet, it is likely to be outdated and conflict with the laws in your state in some way. It may also not have everything you need to protect your company and your employees. So that's why you need to have your social media policy drafted by a licensed attorney. If you are a client, please open a ticket and we will be able to draft that policy for you, or update your handbook if you haven't had a handbook update in a year. If you are not a client with us, this is something that is part of our client services, is to provide a social media policy drafted by a licensed attorney. So we kind of have some political speech do's as we look back on the webinar, and we have some political speech don'ts, which are the things that you don't do. And like I said, I'll get through these a little quickly, but these will be on the slide deck, so you'll be able to see the do's and don'ts. So in summary, both state and federal laws govern regulating political speech. You need to have a compliant social media policy. And of course, always ask us when questions come up, always open a ticket and ask for our advice or become a client, and then open a ticket and ask for any advice you may have about political speech. So thank you everyone for participating today. I realize we went a little long and I apologize for that. If you have questions, please email info@myhrcounsel.com or go to myhrcounsel.com on the web, and you can get more information about our packages and our services. So thank you all for participating today. I hope everyone enjoys the rest of their day.